to be fair, Judge.
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. He was being lazy and unprofessional, counsel. He never spoke to the defendant. Unless she's lying to me, stop, or I'll hold you in contempt.
Just to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me. Sit down. You're done speaking today.
This judge is dealing with a defense attorney who apparently never once spoke to his own client before showing up for a scheduled competency exam. And the fallout is about to blow up this entire case. And to make matters worse, the prosecution have flown a victim out from out of the country specifically for this hearing. Someone already dealing with a serious trauma tied to the very airport that she landed in. When the judge realizes what actually happened behind the scenes, he does not hold back for a second. This one is a wild look at what happens when an attorney's neglect collides heads on with the judge who's had enough. But enough talk, let's dive right in and watch this one together.
People versus Littleton.
Clearly, running on their attorneys still have cross and you record James case, hearing on behalf of Littleton.
All right, ladies, we ready to go?
Yes, Judge, people are ready to go, and I have a complaining witness who flew in from out of the country to be here today.
All right, put her on the stand.
Mr. Littleton, from the competency at this time, defense counsel is adamant that it's revolting, no way understanding the nature or the object of the proceeding and cannot.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So it was the first one that it was a little off. If Your Honor was, I'm not sure if Your Honor was the judge that at that time.
Was not.
Had been statements saying that I didn't think any.
Counsel, my question was a simple one. When did you know you had this problem?
So I'm telling you it's a compounded issue, Your Honor. It wasn't just the first time, it was the second time also.
Denied. Twice I've asked you a direct question, you can't answer it. I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today. I didn't ask for an argument, counsel. I just told you my decision.
Going to be completely, I think to be ready and effectively upon Mr. Wilson had no opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge. As much as Ms.
So schedule a show cause for Attorney King for contempt of court. Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?
Well, understanding it's a different environment that he's attending to at this time because I'm here anyway and because Mr. Wilson was going to refer to comment.
No, he wasn't. You were going to ask for that.
The court was that requires that the court at least consider the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear. And if Mr. Littleton and not assist rationally what is actually happening, actually they cannot move forward. And I think the court has an obligation to consider. Well,
here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not doing. Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Ms. Barrage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. I don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at.
Judge, I contacted Mr. King. I called NDS last week, contacted them specifically so that I can figure out ahead of the PCC the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the probable cause conference. I let him know that I was personally sending in the digital discoveries so that he could review it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring for competency. I also let him know that I spoke to the out of the country complaining witness, confirmed that the next 4 to 6 Wednesdays were free in her schedule, and let him know that we would be flying her in, and told Mr. King that I would make any of those days work, but that if we scheduled an exam for her to be flown into the country, and Judge, this is very important, this happened at the airport, so flown into the airport that she was sexually assaulted in, then if that happened, and if she came here, we were holding this exam. Because I was not going to have the victim come all the way back here, only to be told that there was an adjournment request or have to be referred for competency. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized it was pre-PCC. The PCC happens. I appeared early. I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge meet her where her plane landed at the actual gate to get her from the gate through the airport. Again, she assaulted in to her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave to come here, just to confirm that he's not planning on asking for an adjournment for discovery, to confirm that he was not planning on referring the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him, and that they were concerned about his competency, and that he wasn't sure if the defendant would be able to sit through with this hearing staying.
This is totally unconscionable.
This is where everything really comes out, and it's honestly hard to watch. The prosecutor explains everything that she did to get ready for this hearing. She reached out to the defense attorney's office a full week ahead of time, had an officer personally meet the victim at the airport gate, and confirmed more than once that nobody was planning to request a competency referral. But despite all of that prep, the attorney assigned to the case went dark on her for 48 hours right before the hearing. And when someone else showed up from that office instead, it came out that the defendant had never actually been spoken to. The judge is clearly fed up of hearing this, and he tells the room straight up that this same thing happens to him over and over in his courtroom. Attorneys either not showing up or showing up having never even met their own clients. He says the office is disrespecting his bench and schedules a show cause hearing for contempt, even joking that the missing attorney better bring a toothbrush when he comes in. And at one point, he threatens to hold her in contempt too and tells her to sit down mid-argument. Even with all of that, the case still has to be sent for a competency evaluation, which the judge says could take up to 6 months to actually get resolved.
Which I told Mr. King that we would address the because to be fair, Judge,
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Make sure he brings a toothbrush when he comes for the show cause. Thank you.
if I may, Judge, I recognize I have no actual power to object to a competency referral. And I recognize that. But the way that this was handled, it is one thing to inconvenience me, and I have a lot of respect for the neighborhood defender services. There are several of them here at this courthouse that I have so much respect for.
Me too.
But how this was handled was completely inappropriate, and I told Mr. King that until there was an actual issue in court, we were here, we were ready to go, and I'm at a loss, Judge, because ethically as a prosecutor, I know that I cannot push to proceed when there is a genuine referral for competency. I don't want to compromise my ethics, but this is extremely difficult for the position that we are in. And the reason we're in this position is because of Mr. King.
Well, thank you, prosecutor, for the procedural history. And I can't speak to the conversations that the prosecutor had with Mr. King directly. However, I will remind or just say, that at the times and moments that Mr. King was stating that he did not intend to refer to competency to have to bind over, that those were true statements. And it wasn't until understanding the actual, and not to get into privileged communications and client confidential conversations that we've had, that even at disciplinary examination, even if it is probable cause, and even though he's told the prosecutor that we don't intend to refer to competency until later, it was clear that Mr. Littleton has an issue understanding the order, nature, and proceedings, as well as not being able to assist rationally in his defense. So it's not to say that Mr. King wasn't being honest or truthful, but
He was being lazy and unprofessional, counsel. He never spoke to the defendant unless she's lying to me, King told her he'd never met with Mr. Littleton. Other people from his office had.
I wasn't part of that conversation. I can't speak to them. I'm not
Then I'm going to take her at her word.
lying. Just saying that all the other times that she was speaking with Mr. K, he made the applications and the intention of holding this exam, that was his intention. It wasn't to be dismissive. It wasn't refusing to communicate, that he was figuring out.
Counsel, stop, or I'll hold you in contempt.
Just to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me. Sit down. You're done speaking today.
Done speaking today?
Yes, ma'am. Who flew in?
Judge, the complaining witness in this case, her name is Nora Alfamna. That's spelled Nora, last name AL dash.
All right, I'm going to want her in here in just a minute. Do the paperwork so we can send Mr. Littleton for his competency, which will be 6 months down the road before we hear anything. You guys can take Mr. Littleton back into lockup. Bring your complainant in. Right here, ma'am. Right here. Did you tell her what happened?
I did not. I told her that there was an issue and he wanted to see her and that I would explain after.
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly with documentation to counsel what it costs you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs. You understand that? I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because the system is not treating you well. Thank you, counsel.
Thank you. And again, I just want to acknowledge that I do not believe that Ms. Farage did anything. She just said.
I don't disagree.
In the end, the exam doesn't even happen at all, and the judge has to personally apologize to the victim for putting her through the process of nothing of substance. He even tells her that he plans to make the absent attorney pay for the cost of her trip if he's found in contempt at the show cause hearing. It's a genuinely emotional moment watching the judge take responsibility for a system failure that wasn't even his fault. The absent attorney's lack of communication ends up costing everyone involved, the victim, the prosecution, and the court's own schedule. This is exactly the kind of courtroom accountability moment that just shows how seriously some judges take attorneys' misconduct and client neglect. But drop a comment and let me know if you think the attorney should face real consequences at the show cause hearing. And if you enjoyed this one, make sure to like, comment, and subscribe, and I'll catch you guys all in the next one.